Good evening, ladies and gentlemen, and welcome to the NICG Fireplace Conversations. My name is Edla Kaumbi, and I am the Executive Director of the Namibia Institute of Corporate Governance, the NICG for short. This is episode 2 of our winter series of 2026. This is our platform for advocating for good governance, as we do with other things like our masterclasses and so on. Before I carry on about what we're talking about tonight, I first have to thank our sponsor, 91, who have made this series possible. They were so generous to sponsor the entire series. 91 is a asset management company that operates across Namibia and I think the continent as well. So thank you so much, 91. Tonight's topic is the public, my goodness. How am I blank right now? Yeah. We're talking about the Public Enterprises Governance Amendment Bill that is live. Like literally, it is before Parliament right now, and it's really sparked a lot of debate, not just inside Parliament, but outside as well. And so today I'm joined by brilliant minds who are going to help me unpack it. And so I'm going to introduce them right now. The two guests with me tonight, I'm joined by Dr. Ntelamo, admitted legal practitioner of both the High Court and Supreme Court. He's a director at Ntelamo and Associates. He has served as head of legal services at the Motor Vehicle Accident Fund and as legal advisor and company secretary at the National Housing Enterprise. So you've been inside the SOE system and not just writing about it outside of it. You have been writing about it though too, a lot. You have authored the Manual on the Public Enterprise Governance Act in Namibia and the Law of State-Owned Companies. Dr. Ntelamo holds a Doctor of Laws from UNISA, where his thesis examined the liability of non-executive directors in the state-owned companies, which, given the topic tonight, is quite appropriate. So Dr. Ntelamo, welcome.
Thank you so much.
My second guest tonight needs a small disclosure. He is a co-founder and a former chairperson of this institute, NICG. So he knows better than most what NICG stands for and what we expect from good governance. Escher Luanda is a C-suite governance and ethics executive. He's a chartered director with the Institute of Directors South Africa. He's a fellow of both the Mauritius Institute and this institute, NICG. He's a legal practitioner who holds an MBL. He has advised and trained over 50 boards across Namibia and the region. He has served governing bodies spanning aviation, insurance, and youth development. And so those of you who know about governance in Namibia, you should be no stranger to you. So Escher, welcome back home. So let's get into it. Like I said, we're talking about the Public Enterprise Governance Amendment Bill, which is a piece of legislation that is before the National Assembly. This bill proposes to give the Prime Minister quite broad authority over the commercial public enterprises in appointing boards, remuneration, strategic business plans, and so on. And what we're here to do tonight is not to tell you what to think, but to uncover the deeper governance issue tonight. And so that's why I'm very privileged to have these two gentlemen here today to talk about it, because the debate says, some people say this bill is long overdue. It's about time that we have this governance structure. Others feel it's a grab for power. So we'll uncover this, we'll unpack this more as we talk. So to start off, I think I'm gonna start with you, maybe Escher. So before we evaluate the bill itself, what are we talking about here? What can we agree on? What is the problem that we're trying to solve? Is it fragmentation of oversight? Is it inconsistent board quality? Is it political interference? Or is it the absence of the right kind of political accountability? What do you think?
Thank you so much, Etla, and good evening, our viewers watching from wherever we're watching. What this bill seeks to achieve is to bring coherence to SOE governance, or PE governance as it's called in our jurisdiction. We've traversed long journeys. We've essentially adopted every model of governance, from decentralized, hybrid, and now one feels the whole thinking was if we've tried all these and many of them haven't worked, why don't we go back to the drawing board and go to where we can have a centralized system? Of course, the devil lies in the details. However, my interpretation of what this bill seeks to achieve is more to make sure that you have coherence of how SOEs are governed. We all know the history where we've had situations where one has his own way of doing things. And the only way that you can make inroads is by making sure that you have uniformity, you move away from fragmentation, and you make sure that your policy is aligned from a central source and getting everybody singing from one tune.
Okay.
Yeah.
So you're leaning towards it's definitely to remove fragmentation. Yeah.
Certainly.
Dr. Ntelamo, what are your thoughts?
Thank you so much. Let me also say a good thank you to the viewers. I need to bring in a little bit of context.
Yes.
We are witnessing from one administration to the next. In this administration, you do some amendment to a state-owned enterprises governance act. That was for 2006. There was some amendment to introduce a ministry, do away with council, secretariat, and so on. So we moved from that, we went to PEG, all right? In the time of PEG, in which we still are, we then also saw the obliteration of the ministry.
Strong word, but yes.
And then we are now transcending, as we embarked into or on the new administration, the context was that public enterprises will go back to where they came from, all right? So we see some, I don't know whether this is a reversal. If we take the words of the head of state, it's a restoration of the status quo. But what we do see in the text, you are substituting a minister with a prime minister. The powers that would then have been held, exercised by the minister responsible for public enterprises are then to be transferred to the prime minister's office. So a lot of directives will be churned from there and then be applied by the relevant minister, the Minister of Finance, and so on. So to your question, are we seeing interference? Are we seeing fragmentation? For any governance expert, wherever, you want a clear direction so that you do not seem to go and then you come back. That almost suggests we have not defined where we want to take our public enterprises or how we want to manage them. I'm sure there will be other questions to which I'll speak.
Yeah.
Thank you so much.
Thank you. Because I want to talk about what is the bill trying to solve, right? I mean, even when you're mentioning the prime minister, I mean, already takes me back. I remember when Prof. King was here, when we mentioned, when we had training with the public enterprises, there already was kind of a flag. He flagged the fact that, you know, the minister, even of public enterprises, had so much power, which now is with the prime minister. But I think I want to talk about the Meadco situation that had come up in Parliament, where Cabinet overturned a board decision on a CEO appointment. So is that an outlier, or is that what the current oversight gap actually looks like in practice? Would that be what the issue is? That some of the issues?
I would want to leave that question to my brother.
Okay, our brother.
Thank you so much. And it's a question that I've encountered before, so, and my answer will not change. The Meadco situation, Governance 101, the role of appointing CEOs is a matter for board.
Yes.
I always have reservations about what happened subsequent to that and what could have happened before that. What has been the practice? We all aware that most of the CEO appointments are taken to cabinet, regardless of what the legislation sometimes provides.
Mm.
And one wonders What was the interest in this specific matter? I don't know. So, what I would want to focus on in answering your question is it's potentially a practice that has been adopted, not necessarily in line with existing legislation. However, I would want to look at how do we cure something like this?
Yeah.
If we had a policy provision and all legislation that provides that all CEO appointments be dealt with exclusively by the board without involving the executive, which is cabinet.
The cabinet.
So be it. You don't want to have a system where today you take this to cabinet, tomorrow you don't take it, the other day you take it for endorsement. That creates inconsistencies that good SOE governance should not be about.
Yeah, I think most corporate governance in terms of entities, because the shareholder gets to have an input in this thing, say at an AGM or so. You don't typically have shareholders coming in every time to talk about appointments and executive appointments and things like that. So yeah, hopefully that is something that is looked at. Did you want to add something, or are you going to let it?
No, I think he's covered it. Thank you.
So those who defend the bill, they say it clarifies reporting lines and it improves coordination, which is sort of what you were saying in terms of removing fragmentation. The critics call it a power grab that weakens professional governance. Can both be true at the same time? Could it be that, yes, it brings this clarity and it removes fragmentation, but it also could be a power grab? What do you think?
Well, I possibly may not fall in the two categories that you mentioned there.
Great.
I want to indicate this. When it comes to corporate governance of a company, there are two most important organs. You have the shareholder, you have a board of directors. So the reporting lines are within these streams. So if you are going to have a prime minister who drafts or issues directives that a relevant minister must apply, and if you were to look at the text as it stands now, what I see, my interpretation really, and I can argue this all the way, is that you are going to be having a usurpation of responsibilities that should have been carried out by directors. Those powers are now moving to relevant ministers and to the prime ministers. That's not how governance works, all right? So you are going to witness a situation, if this passes, a situation where the prime minister and relevant minister are involved very nearly in your day-to-day management of public enterprises, to a point where it will be confusing as to the parameters of the board. There are so many cases I could cite here. There is a case, you call it self-cleaning auto. I can't remember the name very well now. I think I remember it. In that court case of many, many years ago, these powers were defined clearly, all right? So that the directors know what they should be doing, and often it's in the best interest of the company. So much so that the decisions that they make, or decisions coming from, or directives, instructions coming from the shareholder, if these decisions, directives are not in the interest of the company, the directors do not apply them.
No,
All right? But just to come back home to your question, the text as it is now, it is bringing some confusion as to the delimitation of powers. And directors may be confused what they should be doing in public enterprises.
Okay, so it doesn't sound like this issue is being addressed. And I'm a little bit concerned, maybe that's a question for another time, because usually, because directors are put in place to sort of oversee organizations, then they are then therefore held responsible. So in this case, if the directors are coming from the shareholder, who will be held responsible? But let's pause, just food for thought. So if the Prime Minister becomes appointing authority, like we say here, what is happening, what does a recruitment committee, the bill proposes, actually do? Like, is a committee enough of a buffer between political will and board selection?
If I may take that one, my concern is why did we just choose recruitment? If this bill is to work,
Mm.
we need to think beyond just recruitment.
Okay.
Governance, leadership at political level requires that we look into issues of recruitment fine, which is often covered under nominations.
Mhm.
We look at issues of remuneration, which I think is covered there.
Yeah.
Reporting. So if this committee is to be effective, we need to make sure that it's a committee that has experts in at least 5, 6 areas, lawyers that can advise, financial professionals who can advise on financial prudence, corporate finance specialists, risk,
Yeah.
and so forth. If I can house the committee in the office of the Prime Minister and give it some level of independence, it can help us enhance this. And with your permission, if I may talk to what my land colleague has just spoken to, I think we need to look into thinking beyond directives and maybe adopt a system that's applied in Kenya. They have a very lean they call it something else, but it's an SOE governance legislation. What supplements that legislation is a code of corporate governance, and it works on an apply and explain.
Okay.
So the minute you have that, you keep the political leaders at giving policy direction at the highest level, but then you have a code that says what should ideally be done. It's aligned to the King reports, and then you work without any concern that this directive is politically aligned. I think that might potentially be able to help us.
So who appoints directors in in a scenario like that, or in those cases? What is their practice, if I may ask that?
Yeah, obviously, even like in the private sector, directors are appointed by the shareholders.
Yes.
They can be appointed by they are appointed by the political
about the CEO.
leaders. However, you follow governance principles which are espoused in the SOE governance code.
Right.
Yeah.
Okay.
It's like bringing your king into the SOE space or
Okay.
your name code.
Yeah. Okay, so if I can talk about the line ministry, did you want to comment on that?
Yes, on the recruitment committee. You see, in the PEGA now, as it is in existence, you have designated staff members. What we have had in the short life that we've been implementing the PEGA is that it gave so much leeway, or it gives so much leeway to the relevant minister to disregard the recommendation. You see, the designated staff members would run adverts and do all that they should do, and then present names. The relevant minister can look at that and take out some names, replace with their own choice, and explain to cabinet. The threshold of the explanation is not known. The law doesn't say. So my fear, and if you were to look at the powers that should now be devolved on the Prime Minister and the relevant minister in terms of appointing directors. So that recruitment committee will not go very far in curing wrong appointments. Our worry is wrong appointments. The moment you leave so much discretion to the executives, I saw something there. When there's a vacancy, for instance, there is no need to go to the recruitment committee. You have something that I should call handpicking. So that we need to take out, because you've got to follow some process. In fact, in other geographies, what they do is they can allow for an auditing of a recruitment process and make it public. Let it be transparent. This is what we did to arrive at these names. Thank you.
Yeah. So I think even what Escher said now, in terms of, like, yes, we shareholders generally appoint directors, yes, but even in that process, even with them appointing, there is a certain process. There is still, I mean, there's ways, either you work through a nominations committee or you have an AGM and names are brought up, but then they are still vetted, because then there's like a merit, yes, that word, where they are appointed based on merit. So I think I would want to talk to that and see that balance perhaps, and how that would be addressed. But then let me also just add this question that I want to ask in terms of the line ministry model. Like each SOE is reporting to its sector minister. So it's effectively what several non-commercial entities already operate under. So the non-commercial entities are already under the sector ministry. Where has that worked in Namibia, and where has it not? For example, what does it actually require of a line ministry to function as a competent shareholder? Yeah.
Can I take that one?
Yes, please do.
I've always believed that basically any of the 3-4 systems of SOE governance can work, provided there's the right level of application. By way of example, as per your question, an SOE like, I can talk where it's worked. I don't want to talk where I feel it might not have worked, because at the risk of offending anybody. Namibia is a well-run SOE with all systems, processes, good governance, integrated reporting, and so forth. And it's under a line ministry model. So that says it can work. However, there's certain absolute minimum requirements that need to be exercised for and it's not just a line ministry. The line minister needs to know what their roles are. I always say it's high level political policy. If they want a certain amount of water availability in the country, that's where the political authorities need to play. You would want them to play a critical role in the nomination and making sure that, as my colleague has indicated, you appoint the right board members who can enhance governance quality. You want your line minister to play a critical role in AGMs. You want your line minister to hold boards accountable. And you would want your line minister to make sure that they don't get bogged down into operational tasks that should not even be at board level, but at management level. So those are some of the non-negotiables that you would want to have in place if you want to have any of this system working. But once again, where you have a dispersed or decentralized system where you spread your SOEs across line ministries, you would want to make sure that you have uniformity across the country. The minute you have some people applying higher standards and others being lax with the standards of governance, then you'll have a problem with consistency. And that's exactly what Dr. Ntelamo has spoken to.
Yeah, because I also want to just think, like the NAMWAT example you cited now. I mean, are they working well because of the line minister, or is it because of the the management that is in there? And because the issues that we're having is usually where the ministers would then interfere with board decisions or work that is supposed to be board oversight work, and not be the policy givers and so on. So is it that there was minimal interference, or is it that that the actual management of the entity just works well? Well, I mean, I can also think of the MBA also is also well run. So I don't know if my question makes sense.
Well, it could be a situation where all the role players understand their bit to the work of the organization. You see, sometimes it comes off as interference. But in my mind, it could be that, for instance, if we refer to a shareholder who appears to be trading on the terrain he or she shouldn't, the question might be, do they understand their role very well? But they also have to be advised. So if each player just keeps to their position and blends the work, all right? You get to an AGM. If you look at company law, it tells you that a shareholder has powers in an annual general meeting. It's not powers to exercise every day.
Yeah, exactly. Yeah.
Because then there's a board.
Mm.
In fact, maybe I can speak to this point that I love referring to the Delaware Code. Directors have so much powers that some of them do not understand they have.
Mm.
And they often want to think a minister has so much powers. But if you follow corporate law, it tells you very clearly the affairs of a company are directed and controlled by a board of directors. Well, that comes with responsibility, and which is why you should be able to hold them accountable. But if you have a mix of the shareholder coming down, directing this, directing that, then directors will not be held accountable. And then, to your question, you will realize that then things do not flow.
So who do you hold?
Yes. And that is where there's an issue, really.
Yeah, because I mean, even thinking in terms of directors, they're supposed to mostly be oversight, really, also, and not really running the company. I mean, they run essentially because they set the strategy and the tone,
Yes.
or the direction of the organization, but also not really. So all those levels then seem to be blurred, from what it sounds like, in terms of giving directors and so on. I don't know, which makes me wonder about the plan that was I think hatched by Leon Jooste back then already, about the holdings company, which was supposed to be sort of maybe mapped or aligned with the Singapore Temasek thing. Could such a plan work for us? Are we there yet? What would make it work or not work? What do you think about that? And what actually happened to that idea at all? Let me start with you.
Well, I don't know what happened to the idea.
Yeah. But can you speak to whether that would be a good idea and whether that could work and under what conditions?
If we are serious about corporate governance, a holding company can work, because there are many models that we can use to create it. Yes, the Temasek that you mentioned, I think Singapore's mentality is different. And they've been very intentional to get to where they are now. And over a long period of time, they have carefully navigated a certain path. Namibia can do that. But we've got first to shift and understand that if we want to grow our economy, let me be a little bit broad. If we want to grow our economy, we will begin to run our institutions properly. And what does that mean? It speaks to some of the issues we are discussing right now. You're going to be having the right people in the positions. Then you can run this thing properly, so that each public enterprise achieves that which it was created or established to achieve, impacting the welfare of the citizenry and so on, you name it. But now, to come back to your question, a holding company can work. But when we started the discussion, I did mention from one administration to the next. So the holding company was a discussion in the previous administration. Right. We no longer hear about it now. So yeah, I'm not in a position to even know what happened to it. Yeah. Yes.
And I mean, you mentioned that Singapore has a different mindset, and we could do it. Like, what would be our mindset? Yes, I mean, I hear you say that we should, if we want to empower people, and then we need to run things properly. But what is that mindset that is needed, and what makes the Singapore model work?
Yes. You see, I also commented earlier that it almost seems as if we have not defined the direction we want to go in terms of our public enterprises. Look at this.
Why do you say that?
Yes, the back and forth. All right, today you have this law, tomorrow you amend it, you bring this, you bring that. All right. Yes, to come to your question of the Singapore model, the Temasek, and the mentality that they have. The question is this. Let me broadly talk about Vision 2030. Today is 2026. All right? How many years to 2030? We can take stock of what is laid out in that document to see what we've achieved of that. So there's not been a lot of weight to the results that we wanted to achieve by then. So that underlines the philosophy that we work with in our administrations. So in another geography, if you set a vision, you rally everybody and all institutions around that vision to achieve it. So today, I can't tell you how far we are with that vision. If we were not able to at least, and of course it was publicized here and there, but not in greater detail, so that even public enterprises in their own individualness would understand how they should contribute, all departments of government, and like I indicated earlier, you are going to grow your economy by making sure that the institutions are performing. Yes.
I wonder, isn't that what the current administration is trying to do with all these committees that they're instituting and so on? And then also with the legislation, I mean, in terms of where organizations should go, isn't that what the establishing acts are for? Or is it that nobody is keeping them accountable to that? You wanted to say something?
I wanted to talk to the Thomas.
Mm-hmm. Sure. Go ahead.
And maybe start off at the issue of where the companies, the holding company model might have gone away, for lack of a better word. Obviously, there was a process underway up until I think about 2 years ago, where there were efforts by both the Ministry of Public Enterprises and Ministry of Public Enterprises and Finance. What happened was obviously the minute you move away, you move to a more centralized system with the political leaders as the owners and shareholder representatives. Obviously, it's not very consistent with the holding company model. But maybe to talk to whether that can work in our jurisdiction, probably not right now. I've seen papers where they have looked at it in the context of South Africa, who I think are advanced in terms of governance than we are. And the key success factors for a holding company model are you need to make sure that your socio-economic, your legal and regulatory framework, and then the culture, which is what he spoke to, is such that we're ready to corporatize our entire corporate commercial SOE sector, consolidate it into one holding company, and the rest of the SOEs become subsidiaries. So with that in mind, I think what we need to do is go on it step by step. Sometimes we get too ambitious. Let's go centralized, get our structures in place. Over time, we maybe set up holding companies on a sectoral basis. Roads, you make them one holding company. Logistics, one holding company. We had it with NPTH, which we've dismantled. Then, in about 5 years later, you try and consolidate the entire sector. I think we need to be realistic. We're not quite there yet in terms of the cultural paradigm shift. Our legislation needs to be harmonized, and that is what what is the country where Singapore has done.
Yeah.
But on a positive side, we need to realize that Zambia has a holding company model in the form of IDC. We could benchmark there. They have had their challenges, but they are picking up the pieces slowly but surely. So it's doable, but I doubt if it's doable in the immediate term.
Yeah.
Or, yeah.
Thank you. So, and I'll get back to you now, but I want to, because you talked about let's centralize first. So isn't this what the PEGA and now the amendment bill, isn't that what we're trying to do? So centralizing is not the problem. What is the problem? I mean, yes, we've said, but can we articulate what centralization looks like without the problems that we are picking up with the current situation?
What is being proposed now does not appear as centralization in the style and nature of a holding company, really. You still
Unpack that for us.
you still have, if you're going to talk of a prime minister with certain powers, the minister of finance with certain powers, and relevant ministers with certain powers, there's no centralization, as it were. If the model that he discussed on a holding company, there's complete synergy. Whether you are going to have, like they have in Germany, where you have a supervisory board and then a management board, the two-tier system, and then your subsidiaries, and that would speak more to a centralized model. The amendments that are being suggested, in my view, do not speak to that. Yes, there will still be some form of fragmentation. Yes.
Escher, do you agree? Do you want to say something, add, enhance?
I think we've covered that substantively. My only suggestion, and I'll probably talk to it towards the end, is the fact that if we do a few good tweaks on this document and make sure that we know what the center of power is and support that center of power, that could be a journey towards ultimately having one central point, and then systematically move towards multiple holding companies and ultimately one holding company. But it's going to take a bit of work.
Right. Okay. I think I want to open it up maybe now to our audience, whether here. Welcome again for those who came in while we were busy. We have a small audience here, and those that are online, if there are comments or questions. Yoram, you have online question. Oh, wonderful. Do you want to read it for us then?
Thank you very much. We have a question from Henrich. He said, how do you integrate King 5 into the proposed amended bill?
Okay. I think I'll let you answer that, but we are looking to revise NAM code. I mean, we've started the process of revising NAM code, so we will want to maybe do that, and we are looking to benchmark NAM code, not just with the King reports, but just other best practice codes as well. But I think maybe the point then would be not necessarily King 5, but I think you spoke to that earlier when we said, looking at governance best practice and then infusing that into what we would want our state-owned enterprises to be run. So maybe do you want to answer that question, Escher?
I think it's a good question. And to me, the answer is very simple. As we traverse the journey with moving from NAM Code 1 to NAM Code 2, if I may put it that way, we need to take into account sectoral differences. And they started it with King 4, where over above the main code, they also have a sectoral supplement. And if you can get a sectoral supplement on SOEs, then part of the job is done. But it needs to come at a price. You need to revisit whether you want to have directives that talk to remuneration, because you can deal with remuneration in the code. You can deal with nominations in the code. You can deal with reporting and compliance in the code.
Yeah. Do you want to add to that?
From a different dimension, you see, when the PEGA was evolving into law, consultation was very minimal. I almost see a repeat. If this bill goes through, it will not be to regulate cabinet or parliament, where it's making the most rounds. Take it to the public enterprises. Let this forum, I think there's a CEOs forum, directors forum, let this thing be debated there. And inputs such as the question suggests will actually come out from there. Thank you.
Yeah, thank you, Heinrich. I hope that answers your question. Thank you for your question. Are there any questions or comments? Other questions or comments from here? No? All right. Okay. So I want to continue because if I understand correctly, the IPC had proposed an independent public enterprise governance commission. So like a professional body to manage appointments and to set standards across SOEs as an alternative to the concentrating of power in the Prime Minister's office. Could that be a solution? Or does it create another layer without resolving the accountability question? What do you think?
I don't know how independent that body should be.
Or would be even.
Yes, and there's no detail in the proposal, or maybe there's a detail, but it's not in the question as you are putting it now. It's not so much about independence of an institution. It is so much competence and independence of the functionaries that you have in institutions. All right? Just as an example, there's an article that I love reading for a lady called Erica Beecher Monas. How far have you come, baby? You know, she details out in the time of Enron, for instance, that there were many non-executive directors on the board, but it still tanked. So it's not always so much in the composition. And she talks about independence and diversity. Diversity more from the mental side of things, the competence side of things. So a body on its own, when you do not have the correct functionaries, might still result in the same situation that we have.
So we are speaking to competence on top of independence, and whether this whatever entity actually has some teeth, I guess. And because the issues that we're having is that directors can be overridden, or that CEOs can be fired, not from the board, but from the shareholders, I suppose. So it's whether whatever entities there are do have that autonomy, I suppose, or mandate and authority to act as they should. Did you want to add? Do you have thoughts about that? Whether such a commission could work? And what would make it work, perhaps, if we're thinking that it could work?
Most of it has been spoken to. There's not much details about what they are proposing, but we all know when an entity that you set up doesn't carry much authority as an aura, there's very little that they can do. There are jurisdictions where that applies. I mean, Kosovo is something of that nature, but once again, this model can only work if there is empowerment to the entity. So I still believe if one wants to live with the current bill, is to make sure that you empower whoever exercises these shareholder and appointing powers, the with the relevant experts that can advise on the key issues affecting SOE governance health.
But is the issue expertise, or is the issue that the expertise gets overridden? And maybe the Kosovo example that you gave, what does that look like? What do they do?
What they do in some of these countries is they will set up an independent commission reporting to a particular ministry. It could be in the office of the presidency, or it could be in the Ministry of Finance. And then such a committee does the monitoring, performance assessments, set governance standards, and all these directives that we're talking about. But once again, where do you pitch them? Where you pitch them depends upon how much power they would wield.
Yeah,
and remember, who you report to matters.
Yeah, for sure. Are you
Yes, in automatic self-cleansing versus Cunningham case that I wanted to discuss earlier, was a situation where the shareholders made a resolution to sell certain assets. The directors refused, that it wasn't in the best interest of the company.
Yeah.
The shareholders went to the first court, they lost, went to the second court, they lost, they came down and sat down. So if you're going to have any institution, when you talk of overriding, The question is, and which is why earlier I was discussing that, do we have shareholders who also understand their charge? What are their responsibilities so that you do not deal with overlaps?
Right.
Let's just respect the provinces that we have as the law pronounces them. If powers are devolved on a board and the legislation is clear, this is what they've got to be doing, and they're doing that, why are you worried? Allow them to oversee, direct, and so on the institution. So, but we also want directors who put their feet down. And when I discuss the Delaware Code, you see what you find in the state of Delaware, which is your corporate capital of the world. They have gone to a system where even the courts of law understand corporate law very well. And they are willing to decide properly. That could also be assisting us. If directors are putting their feet down and a minister acts in this way, removes them. We've seen a lot of removals here. Because you are not taking the decision or the directive I gave you, I get you out. They should be able to run to court and stop that. Yes.
So again, it speaks to, again, everybody understanding their role and everybody understanding their powers and to be able to act on it. Interesting. So as we are nearing the end of this series, this episode rather, so I want each of you to think about, if you were advising the Prime Minister and the Cabinet right now, what would you insist stays in the bill and what would you insist comes out? If you had to advise them, Escher, what would you say? And then I'll ask you the same thing.
That's a difficult one because that's not where I'm going to start. I'm going to start what he spoke to earlier. It's a very sad state of affairs that in the late 2018s, 2017s, we sat with a pegger. I would challenge anybody to show minutes of a single consultation session on the pegger. It went straight from the minister's desk up to Parliament and then passed. The current bill, I think the concern was the lacuna that existed after the pronouncement that Dr. Ntelamo has just spoken to. There was that urgency to fill that gap. But when you look back and reflect, we might have lost about 8 months, to be exact, because we didn't take the journey that we should have traversed. The law reformer in me, which is part of my previous life, says if you want the legislation to have lots of impact, go to the affected stakeholders and get their buy-in. You have governance experts, you have SOE directors, you have academics. You might get a lot more input and fix a few things. But getting to your question, maybe just without going deeper, the things that I would advocate is for us to have a very simple bill that says this is the center of power. I don't have much of a problem if it says OPM, but you don't want a lot more fragmentation. But then on the recruitment committee, I would want to expand it to more an advisory committee and give my PM about 12 to 15 specialists with lots of professional independence to advise them on how to execute this. I would want us formalizing nominations committees that appoint their directors more or less in the same way as the private sector does. And lastly, and most controversially, if we want boards to be the focal point of governance, we need to rethink the whole approach to the way we do strategies in the SOEs. Strategies get developed by boards, but they require ministerial approval. You need ministerial consultation because you cannot have strategy seeking approval upstairs. you would want it being a matter for board. Those are my parting comments.
Thank you. I mean, I'll get you to close it just now. What are your thoughts? What would you advise the Prime Minister? What should stay in the bill, if anything, and what should be done away with?
I have a concern when I see a line that says the Prime Minister's directives will have the force of law. I'm understanding that to mean he or she or they will have legislative powers. And if the text will not be improved to consign the powers so that we know the scope, the contours of the powers, we will find a lot of directives that will be confusing and maybe difficult to apply. A provision such as that we've got to rework. The other concern I have is remove the text that is suggestive of directors losing their powers to oversee governance in public enterprises. Do not take powers away from boards to direct the affairs of the public enterprises so that those powers then go to the minister. They have ministries to run, for God's sake, a lot of departments. Now they want to onboard all these duties. It will be difficult. So such provisions should be looked at carefully. Accounting is one thing. A board accounts to the shareholder minister. That can still be done. But let's not have a shareholder minister to do the work that the board should be doing. Yes.
Yeah, this has been really interesting. And what I'm taking here is, besides the issues that, right now we're having ownership, we're having oversight, and we have policy sitting in one spot, which we hope that's really bad governance. But also, I think what I'm taking here is what we said in terms of wide consultation, which is what we're trying to do now, even with the NAM code now, so that, I mean, stakeholder consultation and engagement is part of good governance too. I mean, it's one of the, the enabling pillars in good governance, especially in the ISO 37000. So, so the governance question here is not just about who sits in the chair, but who the chair is actually for. And I think even as we're talking about expertise, we want expertise that is empowered, right? Because even if we're having all of these people, their power should not be overridden, I think, because you can still have all this expertise, but then if whatever decisions they make is overridden, then it kind of defeats the purpose. So let's split ownership policy and oversight. Let's consult widely, you are saying, and let everyone have the power that they should have, such that the boundaries are not blurred, if that I'm understanding correctly. So if I give each of you one last word, Escher, one last word, sentence, thought.
Let's work together for a successful SOE sector.
That is really one sentence.
Yes, I'm a firm believer that if we want to transform our country for the betterment of everybody, let's pay attention to how we manage and govern our institutions. Because they are the ones that will be counted when we are talking of economics. Yes.
Yeah, thank you so much. Thank you, everyone. Are there any last comments, any thoughts, any online comments? Yoram, you have comments? Yes, go ahead. You may read it. We would love our online audience to feel part of the conversation.
Okay, I have one comment from Domingos. He said, appoint ethical and professional individual to oversee the public enterprises. Enforcement is key and hold board and management accountable.
Yeah, thank you. Thank you so much. Who is that? Thank you, Domingos, for your contribution. Thank you so much. And I mean, we have so much, and we have 5 minutes left, but we've wrapping. Oh, wonderful. There's somebody in the audience.
Thank you. Just on the issue of,
maybe introduce yourself.
Okay, my name is Penny. Speaking in my individual capacity, just as a member of the audience. Briefly touching on a comment from the online. My observation has been that when it comes to now independence and the shareholder appointing, it's been the same faces. So what do we really expect to change if it's like an elite group of directors? It's almost as if it's exclusive to that group, and we don't expect to see any changes because for me it's been the same faces just rotating between boards. So can we actually do something about that? Yeah.
Thank you, Fanny. Joram?
Then I have the last comment from Mr. Henrich. He said Namibia is a developmental state. Therefore, it will be difficult to divorce politically or with political interference from the corporate governance, particularly of the state-owned enterprises. We should not ignore that inevitability and face such as practical consideration that minister will not shy away experiencing their role and capability of the board of directors in terms of skills, skill sets, diversity, and sometimes scarce, and therefore the PM and the ministerial political oversight will be evident on the public enterprises. Just a comment.
Thank you. What would you say to that comment, Escher? Do you want to comment on that comment? You want to comment on that comment?
Yeah,
in
you
1
see,
minute.
Yeah, in my publication, I usually start the journey of public enterprises from the Constitution, specifically your Article 40. All right, we can talk about ministers being political and colleagues, these are constitutional duties that they've got. So if we go on talking political, it almost feels as if we are awarding them an exemption to act the way they please. No, this is a constitutional state. Unless we are saying we can act outside the law.
So explain that in terms of them becoming involved in state-owned enterprise.
If you
governance.
look at Article 40 that I referred to, it ends 40A, I think. It says at the end of it, that paragraph, in the public interest. So my involvement as a shareholder minister should at least be aligned with the interest of the institution in such a way that there are spin-offs to those, the public now.
Yeah.
Yes. If my involvement is to sidetrack the strategy of the institution, then we have a problem.
Yeah. Thank you. Thank you so much, gentlemen. That's been really insightful.
Thank you.
And I really hope that as we talked about, wider consultation with experts and sector people, that this could have been an input, or this will be regarded as an input to that conversation. And as we end off, I again want to thank 91 for sponsoring the series. We're really, really grateful. And I want to encourage you who are here and online to follow us on our platforms, to see upcoming events. For example, we are having a chairperson's masterclass. We are having Professor Tuli Madonsela and Patrick Chisanga. Yes, they will be here, but it's for chairpersons only. So if you're a chairperson on a board or deputy chairperson, we hope to see you there. Do contact us at training.events.org.na to sign up, to ask more information and so on, but we're really excited. And we will see you again next Thursday. We are talking about what governance looks like, and we are going to talk to Commissioner Sam Shivute, because I don't know who hasn't seen what is happening with NAMRA and all the changes. And so we would want to see what that governance look like in practice. So do join us here in person or live. But yeah, thank you so much again for your attention, and for 91 for making this possible. And you gentlemen for spending these last 2 hours with me, hour and a half with me, and contributing to this governance conversation. Thank you so much.
Thank you.
Good night.
Thank you for the opportunities.
Thank you.